to our October. Welcome everyone to our October meeting of the CSBARS. At this time, Adrian, could we do roll call, please?
Yes. Jay Frickberg.
Present.
Michael Clancy.
Present.
Linda Keller.
Present.
George Lill.
Present.
Paul Kramer.
Present.
Jessica Park.
Present.
Greg Murphy. Roll call was taken and a quorum is established.
Thank you. So at this time, we'll have a request for public comment, if any. Members of the public wishing to make public comment can express their interest by raising their hand virtually within Zoom, or by using *9 on a phone if you're calling into our Zoom to raise or lower your hand. They will be recognized in the order that they raise their hands for a period of up to 2 minutes. Further public comment may be emailed to Ms. Leonard, whose address is in our agenda as well. At this time, do we have any public comment?
No, Chair Frickberg, there are no hands raised.
Thank you. We'll move on to our next point, our minutes. At this time, our minutes have been posted prior. Does anyone within our committee need more or additional time to review them?
No.
Are there any motions to adopt or to discuss further the minutes as presented?
I'll move to adopt.
This is Michael Clancy. I second that motion.
As it has been moved and seconded, I hear no opposition. Ms. Garrett, can we have a roll call vote to adopt the minutes as presented, please?
Yes. Jay Frickberg.
Aye.
Michael Clancy.
Aye.
Linda Keller.
Aye.
George Lill.
Yeah, aye.
Paul Kramer. Jessica Park.
Aye.
Paul Kramer. I think you're on mute.
Yeah, sorry, aye.
Okay. Roll call has been taken.
Thank you. And our minutes have been adopted. At this point, we'll now turn to our staff report.
Thank you, Chair Frickberg. I'll take that first. I'm Natalie Leonard, working with Educational Standards, and I'll be talking about several topics. The first one is a brief summary of the Registrars meetings and the Law School Assembly. For the benefit of the public, these are annual meetings. CSBAR holds them once per year. This year they were held on Zoom. The Registrars meeting is targeted toward issues of interest to registrars, but other members of the law school community are able to attend, including many members here from CSBARS. We've now done it in the online format several times, and there was a very wonderful, specific, and lively discussion at the Registrars meeting on a number of different topics, largely questions that were brought up by the school. Notably, one of the things that was solved even in advance of the meeting was a further update to the bar exam application, helping students to understand how the state bar communicates with schools to certify their eligibility for the bar exam, with the hope of creating student certainty, but also reducing the number of questions that come back to the registrar's offices. So as a result, we've added a tooltip to our AIMS applicant portal system. And we've also reminded registrars that they should hopefully be sending their certifications in every week. And 2 weeks prior, we do send a reminder out to the students. So if all of the certifications can be in prior to that, it is a big help. As to the Law School Assembly, that's generally targeted at the dean of the law school, but also other administrators can attend. We spent a morning discussing the data that the state bar collects, as well as that schools collect regarding diversity in the legal profession and in law schools. We also provided some background that we hope will help the accredited law schools as they begin to create their diversity, equity, and inclusion plans that they'll be creating throughout this year and next year in accordance with the new rules. We were very happy to hear from University of West Los Angeles, UC Irvine, and also UC Hastings about their plans, and to bring our guest, Dr. Lisa Moore from the University of Chicago, for some insights about constructing a strong diversity, equity, and inclusion plan. I wonder if there are any comments from members who may have attended or may have had staff attend either one of those meetings. Chair Fickberg?
I attended both. I always find them very interesting. For the registrars meeting, I thought was very excellent was the demo of the Ames portal. That's something that's always been difficult, I think, for me and some of our staff to walk our students through. As an example, historically, with the moral character application, when it was in a printed version, we could look at it with them and talk to them if they had questions and direct them to staff membership. So being able to see what the students are seeing, I thought was extremely helpful. I think also hearing from others the ideas, and this I think was echoed in both the Law School Assembly and the registrars meeting on registering as law students. That's always been a perennial issue at my institution, and I hear at others, convincing students of the benefit to do that. That was excellent. It was also surprising me because we use the poll feature, which I like. I do that when teaching. I was happy to see staff using that in these meetings. That almost a third in the registrars meeting were there for less than 2 years. I want to say it was like 30-31%. That was surprising to me because that's a very technical job. So again, I think by having that registrars meeting, they know to reach out. They can reach out to each other and cross-pollinate. So I thought it was a very beneficial meeting.
Great, thank you. Any other comments regarding these meetings? Thinking ahead, we will have others in the future, and we also have other communication vehicles like the newsletter throughout the year. So we encourage the members here, but also the schools watching, to think about the questions that you have, the topics that you would like to amplify or reinforce with your students, or the strategic topics you might like to hear in the future in the Law School Assembly, because we really do like to tailor these to what the schools need most. And your ideas are what help to make that happen. So thank you. Next topic is also one that I will share, which is a plea for help from all of you on the topic of State Bar Day. So many of you know that we started a new program that we've run a couple of times, which is a State Bar Day, and it is targeted towards students. We bring different leaders from different parts of the state bar, some they may have seen before or not. Every time we do it, we have more and more interest. We now have actually even had to license additional spaces on our Zoom account to handle the demand. So we feel like this is something we want to keep doing, and we want to bring schools in. We'd like to know the time of year that you think is best for this, whether or not you think all students would like to meet together or segment the students, and what should be included. We introduced this idea in the most recent newsletter, and we'd like to get more feedback about how we should plan for this in 2023. We'd also love to know any comments that you've received from your students about the State Bar Day as well. We hope to adopt some of the successful features of the law school meetings to the State Bar Day to make sure that we are collaborating with you to get the right information to students at the right time, including to help students understand the resources that are available to them, not only at the time that they apply for a state bar exam, but also as they pursue their careers, such as through the lawyer assistance program, or knowing that they can apply for testing accommodations before they apply for an exam. We want to do our best to get those messages out. Are there any initial thoughts about a State Bar Day program and what it should include? We will also send follow-up after the meeting too. Dean Park.
Hi, I definitely know that for the online students at Abraham Lincoln University, they've really appreciated a chance to be more aware of how just engaging with state bar departments in a different way, and are very appreciative of any support, anything that helps them make the process easier and to tackle it correctly upfront the first time. Definitely helps sort of lowers the barriers of entry, I think, in going through the process. Just in terms of suggestions, because we start our students in our program throughout the year at 3 starts a year, I think we're pretty flexible about what time in the year there is an event, but if there is some sort of annual mixer, whether virtual or in person, I think just sending it out well in advance and making sure it's something that law schools can point to, point to where the RSVP a link is, it's helpful. And I imagine, possibly figuring out a good time between all the bar exams will be good as well, because same with how students are busy with law school exams when they have those in our calendar. There's people who will want to engage, but will feel more tied up in different cohorts. So I just suggest scheduling sort of off calendar from the ramp up to those state bar exams, whether the first year law students examination or the California bar examination. And I think I had one last thing related to State Bar Day, but I'm losing that thread. So if it's important, I'll email it on it later. Thank you.
Okay, terrific. And I would encourage anyone who does have a suggestion to send it on over to me or to the law school regulation box. No need to wait for a specific announcement for the meeting. We will look at the comments throughout the year. And if there's something that we can address throughout the year, we won't wait. Okay. All right. Thank you. And then for the next topic, I would like to ask Shakar to please promote Carolina Almirante, who will join me. I want to talk a little bit about the annual reports for both accredited and unaccredited law schools. So today, after the meeting, there'll be an update to the unaccredited annual report, and the accredited annual report will issue. With respect to the unaccredited annual report, it will look identical to past years, with the exception of the planned change to expand the demographic categories that are collected. In this year, the final year of the 3-year rollout, we are asking schools to report information for both faculty and students regarding LGBT status, and also veteran status and self-identified disability status. That will be the same for both unaccredited and accredited. In the case of the accredited annual report, we are still in the transition phase. The new rules went into effect on January 1st, but all accredited schools have 2 full years to come into compliance. So to support that transition, the annual reports have been adjusted. They have adjusted rule references as to the new areas, but they are largely in the same order as in the past, so that whether a school has fully transitioned or is in the process of transitioning, we think this document will work for both. If a school is in transition in a new area, we expect this the most in 4.160C, the Diversity, Equity, and Inclusion Plan. Then the school can discuss their current status and their plan to come into compliance by the end of the year. To make sure that all of the schools feel comfortable, both unaccredited and accredited, once the report forms issue this afternoon, we'll be contacting each school to set up a check-in meeting, talk about best practice tips, talk about the questions that your school has specifically, make sure that your contacts that are working on the report at the school know how to reach us with questions. And we also plan to schedule 2 workshops or study halls or office hours, which we are going to try as a new thing during the week of October 31st. And if there is need, we can do a second set of those study halls during the following week to help ensure that everyone is ready. Another element that we're adding here is specific dedicated support from our Office of Research and Institutional Accountability. And I'd like to introduce you to the key contact for that support, Carolina Almirante, who is here to greet you. we're just going to unmute Carolina. Thank you.
Hi, good morning, or good afternoon. Can you hear me?
Yes.
Okay, great. Thank you. Thank you, Natalie. So again, my name is Carolina Amarante. I'm a senior program analyst with the Office of Research and Institutional Accountability. As Natalie mentioned, Araya is supporting the work with the annual report, specifically looking at the data metrics. So it is a team of analysts that are helping with the review of the data. And one of the things we want to highlight is we are wanting to provide support to the schools as they're collecting that information. So any questions, as Natalie mentioned, regarding the data metrics, we are happy to assist in clarifying as much as we can. And as the reports come in, we're also working with Natalie, reviewing the data, and again, happy to answer any questions, get on a call. And in the event that we may have clarifying questions, we want to respond to you all very promptly. So again, we're here to support. It is a team of analysts. And again, any questions regarding the data metrics, we're happy to respond to.
Thanks, Carolina. We're very glad to bring the support and to front load it before the due date of the deadline to be here for all of the schools. And while we have Carolina here, I wanted to just point to one element when you see it. You've been planning for your demographic data by using a spreadsheet that you've had now for the last 3 years. You saw it with your 2020 report, and you saw what would be asked in 21 and 22. This year, the spreadsheet asks for the same information, but it looks different. We have only 1 year left, and we've asked for the same information, but we've changed the format in a way that we think will be easier for you to fill out based on feedback from last year. We think it will be more clear, and there are more checks in the file to double check. As you're filling in, if there is an issue, it'll be highlighted to you right away to make it easier. And in order to do that, we stretched it out to 6 different tabs. So when you look at it, the first thing you might ask is, wait a minute, has this data changed? I've been planning for this data for the last 3 years. So we want to assure you that it hasn't. It's just the structure, but asking for the same numbers inside. So that's something to watch for when the first time you open the Excel data. Okay, well, thank you. That's the update on the annual report, and appreciate Carolina attending and look forward to your support of the law schools here and watching either in the audience or on the tape. Our next topic is the first year law students exam, and I would like to turn it over to Audrey Jane.
Good afternoon, everyone. We are swiftly approaching the first year law students exam. It's October 25th. And I just want to highlight a few things for you, which I imagine you're already familiar with. Well, the final eligibility deadline was yesterday. We have about 270 test takers approved. We are using Prometric as the vendor to administer the exam primarily remotely. The major difference with Prometric is that the proctoring will be via a live stream in the candidate's webcam. So that's a major difference. We put a lot of communication out to the applicants already, email communication to them. It's updated on the website. There's an FAQ on the website if you haven't seen it, going through kind of what are the differences with Prometric and ExamSoft, which is how we've been administering the first year exam for the past couple of years. If they requested the ability to test in person, so they have extenuating circumstances, either they don't have a quiet place to test or they're worried about their connection, we have honored those requests, and there are folks coming in to the Los Angeles office or to Prometric's in-person testing centers, which they have several of those across the state. So I just wanted to highlight that just because I don't think we've talked about it directly yet in one of these meetings, and just want to make sure that everyone knew that the exam is coming up and that we are using Prometric as the vendor.
Thanks, Audrey. And that concludes our staff report.
Thank you. That brings us to our next issue, discussion of potential changes of our last itemized discussion on 1.11. Is it possible to bring up a printed copy for everyone to see? And then potentially we can have Dean Keller or Chair Kramer lead that conversation. That way it'll be a more pointed one, I think. And we hopefully won't meander too much.
Sure. And for the benefit of the public, might I give a brief summary while Shakar is bringing up the item?
Please.
So the CSBARS has been working for a number of meetings to create an amended version of Unaccredited Guideline 1.1, which is focused on the conditions under which unaccredited law schools can incorporate bar exam preparation programs into the law school curriculum. The CSBARS adopted a consensus version at its last meeting to be shared with the Committee of Bar Examiners on Friday. There is a staff memorandum that's up that I know that the members have reviewed, the CSBARS members have reviewed in advance of the meeting. We will often just generally post that memo for comment from CSBARS, but in addition, when the group looked at the final item, a couple of suggestions did emerge. So the committee has been alerted that there might be some additional changes to be discussed here. And if the committee decides to adjust its recommendation today, then that adjusted recommendation will be posted to the Committee of Bar Examiners tomorrow. So at this point, I'll turn it over to Paul Kramer and Linda Keller to discuss those proposed changes.
So Linda, maybe you can describe your concern first, and then I'll explain. And Natalie asked me to look at it, and so I did. And then I discovered another, well, less than perfect sentence structure, and one other change to make that I propose to make to the particular paragraph.
And
So,
since we'll be discussing changes, I'm going to ask Shakar to bring up the Word version of the guideline so that we can do some editing on the screen and follow along with the conversation.
if he doesn't have it, I have just the particular paragraph available to share.
We should be able to put it up.
And while he's doing that, I'll just briefly summarize. So this, comes towards the end of the language, last paragraph about consumer protection, referring to disclosures of any interest in an external commercial test preparation course. The way the language was originally drafted, it seemed like it was saying you need to disclose interest only in test preparation courses that are actually provided by certain members of the law school. From my understanding of our conversation, the issue was not that they have financial interest or ownership in courses that they're providing, but rather in the external commercial test preparation course. So I had made a suggested change, sort of keeping the order as it was, and adding in a clarification that we're talking about the interest of the school or its owners, administrators, instructors, and staff, rather than having that language of owners, administrators, instructors, and staff at the end, modifying what type of course was provided. And then Chair Kramer made improvement there in terms of the placement of that clarification. So this, it reflects that improvement, as well as the change for from ownership interest to financial interest, and I'll let him address that aspect.
Yeah, so it would expand from just owner.
From you. That's overshadowing your voice.
Paul, it's your mic. Maybe you need to call in.
We can't yet understand you.
It's probably worthwhile to mute his mic on our end, whoever our host is at this time, if he's going to call in. Otherwise, we'll get that echo. It'll be even worse. Thank you.
Okay, yeah, we've muted his mic. It was previous. I'm thinking that he's going to call back in on the telephone for his audio. And I think that will help things. So while he is dialing back in, for those that may not have seen this before, for the members of the public, this was a smaller guideline before that actually did not allow the test preparation to be a required part of the course. That will change going forward. There is a definition of what a test preparation course would be. There is some information about when the course can be used, a potential maximum number of credits for courses, though that is not specifically recommended by CSBARS. It's offered for guidance. So that's what we're discussing here. In the meantime, Linda, Dean Keller, I don't know if you want to discuss the change while we wait for Paul
Also,
to return.
we have a phone that has called in with the attendees. I don't know if that is Chair Kramer. If it is, we might want to promote him from the attendees, but also rename him if that is his cell phone, which I presume it is.
Thank you. Shakar, would you mind doing that?
Okay, is that working?
Great, thanks. Thank you very much, Paul. Oh, echo.
Yeah, let me, hold on.
I think if you mute your microphone on your computer, it may help.
No, it was the speaker. And okay, we good now?
Great, thank you.
Okay, so yeah, all I was wanting to say is that a financial interest is broader than an ownership interest, and that would cover things like law professors, moonlighting as teachers in bar prep courses and that sort of thing, which should be disclosed. And that's really all I had to say about this. I apologize that somehow we didn't catch this the first go round, because I was the guy who was doing the keeping of the draft the last time, and somehow I checked what I sent out after the meeting, and it did have this particular misplaced modifier. But now we can fix it.
And I believe Dean Park has a comment.
Yes, I do. Thank you. So I'm looking back through here, and I know this language is focused on a particular external commercial test preparation course. So I'm trying to just walk through a hypothetical so I understand the broadening. So for example, let's pick Barbary just as an example of an external commercial test preparation course that is out there. And let's say a law school grants credits for or promotes uniquely or specifically to its students for that. So when we had the ownership interest before, that is if the law school or the owners, administrators, instructors, or staff, any ownership interest in Barbary. But if it's any financial interest, then it's a question of disclosing any anything of financial relationship between the law school and Barbary, the owners, administrators, instructors, and staff with Barbary, including if the instructors had ever taught at Barbary before. Is that what's intended with the any financial interest broadening? And this is just a hypothetical to walk it through. Again, I want to make sure we're serving consumer protection, which is the purpose of this, but just to be sure.
Yeah, I don't know how far you would reach back if
Maybe
somebody
current
isn't
interest
present.
rather than past, right? Because there's
Yeah,
some
if you want to
professors
get that
that
fine
say,
grain. But yeah, but a financial interest includes an ownership interest, so it's just broader than ownership. That's the main point I was trying to make. Yeah,
just
I don't
want to
know if,
understand how broad we're making it. So I'm guessing this is more if a law school instructor is currently teaching at that company, that gets disclosed within this disclosure requirement.
right, or if the law school was getting some kind of remuneration for recommending a particular provider, for instance.
So disclosing that that contract, let's say, not the full contract, but disclosing this exists and this is the type of compensation the law school gets.
Right, because it's a potential indicator of perhaps some bias in the recommendation that they've made, and students should be aware of that.
Okay. I just wanted to be sure to walk through that. I do think ownership is much more narrow, so I understand why it's broadened. Just want to be sure if law schools understood. I mean, not everyone's going to grant credit for a particular external commercial test preparation course, but should they choose to do so, they would understand what type of disclosure meets this broadened language.
And just a point of clarity for Chair Kramer, Dean Keller, the red line edits that we're seeing that we were just discussing, those are only proposed edits, or are there any other additional edits?
I believe there was another suggestion from Dean Park. I can share my screen to show it, but before I do so, I want to point to where we are on the top paragraph that starts with a test preparation course for which credit is granted. She had a cleanup suggestion regarding the second line where we see provider, provided, and provides in the same line. Dean Park, would you like me to show your suggestion on the screen?
Sorry, I forgot to unmute. Yes, that would be great.
Okay, great. Oops. Okay, so this is the suggestion from Dean Park regarding that line, and if it looks reasonable, we can also show it to you in context.
It's a small thing. I think it just removes one of the provides used. So.
And so now that we've seen this, I'm going to take the stop share off. I'm going to ask Shakar to edit the version that he's got in the Word area to replace the second instance with as long as to match the suggestion. And Shakar, are you ready for me to stop sharing my screen? And then Shakar, just let me know when you've made this change, and then I will take the stop share off.
Excuse me, I've made the change.
Okay, great. I'm going to return control of the screen to you. Thank you.
Thank you.
Okay, so I believe that this is all the feedback that we received prior to the meeting. So Chair Frickberg, I'll look to you as to whether you believe there are additional questions or concerns, or if you are ready to see if this is a consensus modification.
Dean Leal has his hand up. Would you like to speak on this matter?
Well, more for clarification. So, and I'm trying to, wrap what this proposed amendment would do to my current program. So is the intent to this disclosure and regarding any financial interest of the law school or its owners, administrators, instructors, or staff, is that's being directed where my school would promote an independent bar review course, say we have Barbary or whatever, and we tell them, you might consider going to that separate bar review prior to the bar exam, as opposed to what we currently do, which is we've retained in essence an independent contractor who's had a bar preparation tutorial company for many years, and he's not part of our faculty, but he's teaching a class, and he clearly has an interest in his own business. So if we, and it was pretty self-obvious the way I promoted it, because he had promotional materials as to who he was and the name of his company. So I would assume that I complied already by informing my students that the bar review instructor or tutor that we have working with him has an interest in his own business. And I don't, because it almost seems tautological in a way. I mean, but that's why I'm asking, to make sure that we know I know what we need to do. Maybe I wasn't.
Well, it sounds like he's not a owner, school owner, administrator, instructor, or staff. He's a contract.
Well,
is he even a contract employee?
Well, he is, we have an agreement with him to pay his, his fees to come in and do what he's been doing with our students. And so I guess he'd be argued as he's currently an instructor, in the sense that he's there providing educational services to our students in this bar prep course. And that's the point of confusion I have, is he's not, an owner of the law school. He's not an administrator. He's not staff. He's not actually, one of our members of our faculty, but he is instructing. So I guess I don't mean to overly complicate it. I just don't want to, I just want to know, once this becomes an enacted, guideline, as to what we should do. And I think we've already complied it. I mean, they know that has an independent company, and that's who he is. And the assumption is that he makes money doing it. And
So you're saying you have disclosed that information to your students?
Yeah, I mean, he has, he had a brochure and a flyer, and we, again, given his extensive history and what he's done and who he's worked with, they know that he's a separate commercial entity from the law school, and that he's been hired by the law school to teach and to tutor in our bar prep course.
Yeah, I guess you could just confirm with staff that what you're already providing is adequate disclosure.
Okay, well, that would be easy. So
I mean, in the first instance, it wouldn't be my job to tell you that.
yeah, no, I know. That's my question is open-ended in terms of. I mean, I guess it's the idea being, schools that have advertisements or let Barbary or bar tutors come on campus to meet with students, or maybe on Zoom to sell their services. And if that person in that company, there was a financial interest held by the people and entities enumerated here, owners, administrators, that clearly would be, I think, required under this amendment to have the school say, oh, by the way, you know, the owners of the school are a part owner of this entity. So that to me is clear. It's this more hybrid situation where we've brought in essence, a separate commercial entity, and for this semester, he's an instructor, and yet he has he clearly has a financial interest in his own business. So maybe I'm tying myself into nuts.
Yeah, your last example there isn't as clear to me, because I think the language promotes uniquely or specifically was meant to say that if you just let everyone on the campus, you know, to promote themselves to your students, and you're not really promoting them
Or endorsing them. Yeah,
yourself.
I guess you're right. I think.
But over disclosing isn't a bad thing either.
Mhm.
I mean, who knows? Maybe some students really like the instructor and they'd prefer to see him or her again in their bar review class.
Well,
Never know.
that actually happened with the two students that we had. They continued on with him because he was providing one-on-one tutoring. So, all right, no, I think you're being. Thanks, Paul. I think I feel comfortable in that what we're doing is appropriate, or will be appropriate under the new guideline.
One further point of clarification, just for our committee members, is there any discussion just on changing the word ownership to financial? Can we parse just that one issue out, changing from ownership to financial? Any current objection or discussion on changing that word?
I think it does get a lot broader. I'm not necessarily objecting to it, but I think when it was ownership before, you know, the whole idea of past or current didn't even occur to me, because I think if it was ownership interest, you know, so I think I have a question for clarification about this. Is this any financial interest? Is it just implied that it's current financial interest? Then I think that's pretty reasonable. But if it's a situation where, you know, they have to retroactively disclose whenever they were a part of Barbary or Fleming's, I don't think that's reasonable. Now, there's a way, of course, that could actually turn into positive marketing of having, you know, a faculty member involved, so it's not necessarily a bad thing to disclose, but again, to be able to show clearly and simply that you are meeting the standard. I just think maybe current should be in there, but if everyone agrees that it's implied enough, then I could be open to this language as is.
Well, as an example from our dialogue, would there be any objection if before financial we added current known, or are we taking something that's implied and making it express? Current known, current from the conversation from Dean Park, and then known from the example from Dean Leal, where we might have faculty, adjunct faculty that might be working for a bar review company, you know, ABC company, and the school's not aware of it. I think we should have the schools ask that, of course, but if we're putting this obligation on the school, that they would then have an obligation to disclose all current known financial interest, ... through the rest. Any discussion on that, adding current known?
Not only from a staff perspective, I have a question about adding the word known. If there is a responsibility for the school to know, sort of on a know or should have known level, then perhaps rather than known, it might be appropriate for schools to understand that they should occasionally poll their faculty, so that they will know in those cases. A concern is that if known is listed there, it may disincent the schools to be vigilant.
Is there any objection then to current? Current going from implied, potentially from our conversation, to express within our rule statement? Current.
I'd be in favor of adding current. I think that clarifies it sufficiently.
Any comment from Dean Keller or Chair Kramer?
I have no objection to adding that in.
No objections, but there's something missing here in what's on the screen. Let me switch to my other copy.
If I may, I think what dropped out was that previously we had left in at the end, in that external commercial test preparation course, just to be very clear what we were talking about, interest in what. I'm not sure that that's necessary, given the rest of the sentence seems pretty clearly focused on the reference to external commercial test preparation course, but that is language that Chair Kramer's, what he had circulated to me and originally kept in.
Yeah, if I can show my screen, Natalie.
Sure.
You ready for me? Okay.
Yes, and then Shakar, will you make note of what he posts?
So this part here is what fell out. And I think it's useful to complete the sentence. And then we can just add current. Sorry, this is hard coded, so it's not track changes. I think that's what we're looking for.
Mhm. Okay, and then Shakar, let us know when you've got that, and we'll switch the screen back to you.
All right, I'll stop sharing. Is everyone ready for that? Okay, here we go.
Thanks, Paul.
Now, as presented, again, solely looking at the proposed edits from Dean Keller and Chair Kramer with the modifications from our dialogue today, is there further discussion on that language? The language of the paragraph we're looking at, the second to last paragraph. Hearing none, I think we have consensus there. Before we put that to a vote, though, if we could scroll up, please, for the proposed edit from Dean Park. Did we lose that one?
No, you scrolled by it.
Okay.
Scroll down now. It's in, I guess, purple right there.
Yeah. So now, is there any discussion from our committee membership on the new proposed language from Dean Park in the third paragraph? Dean Keller?
Yeah, I think that's fine. Eliminates the triple provide references. I don't have any issues there.
Not hearing any further points. That was probably one of my feelings of always wanting alliteration. I have a tendency to do that for some reason. With that said, any further discussion on 1.11 currently before we entertain a motion? Dean Park?
I just had one quick point, and it was in response to Dean Leal's question, and it'll be quick. I think for me, when I was looking through this language, the introduction of external commercial test preparation course provider to me, or external commercial test preparation course, to me, that specifically meant when a law school grants credit or specifically promotes but we know it's a course that's very much being run externally, that the law school has then, checked that it has met. The law school is providing oversight of the course through all these requirements and the guidelines in that paragraph, but otherwise it is an externally run course. Let's say even the law school is not necessary. The law school is checking certainly on the quality and the oversight of what that course provider is choosing for instruction, but it's not necessarily being run by the law school. That was my interpretation of it. So for me, I think something that's not an external commercial test preparation course, it wouldn't include something that the law school is running for its students and giving and granting credit for. To me, that's a part of the law school's curriculum. And we are assuming and thinking that the law school's handling it like the rest of the curriculum offered. And I think it just goes, why did I go through this? This goes back to another point that I had, for example, in your curriculum outside of bar prep, if you have a law school professor that licenses books and materials for that certain topic, that's usually not seen as a consumer protection scare. So to me, it's just when it is something that's part of law school curriculum, when it is disclosed how the staff is engaging in the materials and resources for that curriculum, it's just run that way. That's not under this guideline, but something that's not a bar test preparation course at all, of course, is not under this guideline. But when a test preparation course for which credit is granted that may be taught by law school faculty, it's being run by the law school, it doesn't go under the same consumer protection standard to me. And I think this language articulates that clearly enough, but if not, that's why I wanted to raise this last point.
It was my understanding, and then we can open for discussion, that specifically 1.11 in our conversation was to allow schools to award credit for test preparation when they're currently prohibited absent the waiver. And so I would not see a distinction in that third paragraph, whether the test preparation course is in-house, as it were, taught by that institution's faculty, or they contract for a third party to provide that service. Either way, to me, the controlling component is which credit is granted, right? The credit being granted is what's triggering to me and everything in that paragraph that must occur so that a registered school may award credit. Was I misunderstanding that, or am I misinterpreting your language from a second ago?
Oh, no, I agree that like for the third paragraph, the standards applied whether the course is taught in-house or external commercial test preparation course is the same. When it comes to the fourth paragraph, though, and how to meet consumer protection there.
I was just waiting for the car to scroll down for us. Thank you.
No worries. I just wanted to point out that's why I see it limited to that external commercial test preparation course scenario. And I didn't see Dean Leal. I think when the law school is truly running it in-house, I didn't see it fall under the fourth paragraph to me. So.
And I think from reading it, or that first line of the fourth paragraph, law schools must not compel students to attend a particular external commercial test. That's what I was focusing, is controlling throughout that one. Dean Keller, you have your hand up?
Yeah, sorry, I didn't mean to cut you off. Yeah, so I was just seeing if I was hearing Dean Park correctly, that she's suggesting that if a law school is hiring someone as an independent contractor to come in and offer the course as an instructor / tutor, then is the question that Dean Park is raising, that she does, whether that person even would fall under an external commercial test preparation course provider. Am I understanding that correctly, that Dean Park, you're implying it wouldn't even fall under that. So there's no question of whether you're disclosing properly or not.
Yeah, I don't think there's necessarily no question, but maybe again, this is just what I thought was implied. When I think there is a test preparation course for which credit is granted that may be taught by law school faculty, my understanding that there is a lot of control in-house. Sorry, I'm hearing me echo a little bit, but there's control in-house. Even if it's a contractor, that person is working with the curriculum standards or, you know, the course design that's procedures that are established at the school. When it's an external commercial test preparation course provider, and again, this is how I had looked at that language, the course is built outside the school. The law school is just providing oversight to check that that external building of that class meets with the guidelines that are here, right? So I think it's a little bit of a matter of, and I thought the guideline language was doing it clearly enough. Just this is distinguishing how that course is built or provided to students. And for example, if you're hiring Barbary to develop a course for the law school for credit, but it's ultimately a Barbary product, and I think it's very clear that it's a Barbary product, that's where I felt like, well, why the law school is doing that or granting credit for it or promoting uniquely specifically for it, that's this consumer protection section. But if it's a matter of, no, this is a law school bar prep course where the law school is developing it and granting it for credit, and you happen to have an instructor that had Barbary experience as part of, that's the law school hiring in someone to ultimately run a law school course, a law school prepared course. I don't know if I'm filling in so much detail in terms of how I interpreted that. It's causing people to recheck things. That's not my intention, but that's when Dean Leal raised that question. I thought, oh, I didn't necessarily think his situation definitely fell under the consumer protection paragraph. That being said, like Member Kramer said, over disclosing so that students are very clear about what they're getting and the value of what they're getting is certainly still optimal and good to do. But I just think it's important to know for the law school compliance department, what's required.
Well, again, looking at the top paragraph in our display, I believe that was solely focused on accreditation regulation of the academic component. So that encompasses everything, whether internal, external, from our dialogue.
Yes.
The next paragraph focuses more on consumer protection and disclosures. So I think that would also be equally applicable to internal or external. It just might be self-evident if it's an internal one, institution A's course that we charge X amount per unit for, that's disclosing the ownership interest by that institution. But I think there's shades of gray in between that I believe, without speaking for Chair Kramer, he was trying to bring into the light as we went through here. As an example, if an institution was partnering with an external bar review and there was some type of, lack of a better phrase, kickback, some benefit financially to that institution for referring students in that direction, that should be disclosed, because then I think students then would say, am I getting the best recommendation for the fiscal health of an institution or the best recommendation for my ultimate bar passage or passage of the first year law students exam? I think either way, I think would be equally applicable, but I'll definitely open up that for conversation with our committee members.
Mm-hmm. I think this language does cover that with the promotes uniquely or specifically to its students. If, for example, that's happening for Barbie's example, there's also other companies as well, like Bemis and Fleming's, just to be fair. But yes, if there is that specific unique or specific promotion, then that would trigger this consumer protection as well. And that goes outside of the situation where the law school is granting credit for a particular external commercial test preparation course.
Any further conversation from our committee members on the language now as presented in the current edited form? Dean Leal?
No, I think it's a very impressive group think effort here, and I would support all the edits. And also just wanted to make the comment, I think, and consumer protection, of course, is always important. And the reality, though, is I think it would be hard to believe that any of our schools that are regulated, overseen by the committee, would somehow be looking as this as a means of an additional revenue stream. As an example, the reality is, in my situation, in my school, is my ownership is certainly motivated and generous enough. We're subsidizing it. Our students are paying literally half of what this commercial bar tutor is charging this school for each student. And I think subsidies are probably far more common than a profit from something like this.
No, agreed, Dean. I think that the registered school, the accredited schools, this is more of a concern on paper than reality. But that's why I think it does not hurt to have a rule against it. I don't think this is a line that institutions are crossing. But if they did cross, I think then we would all agree they should not. Any further discussion on the rule as presented? So hearing no further requests for discussion, I would entertain a motion, if there is one, to adopt the language as presented.
Oh, one quick question, Team Frickberg. So are we going to, this idea of the last bracketed suggested edit, the 15% limit, I guess would like staff to, how is that going to be presented to the committee in terms of how they'll present it? And I have the memo, and frankly, I read it the other day, I forget. If I remember correctly, it's that CSBARS doesn't support a limit. However, staff, based on committee input or whatever, does. So is that, and then it'll be just thrown to the committee to make that decision after some discussion?
The current intention, Dean Leal, is that that Chair Frickberg will also attend the CSBARS meeting. He's scheduled to do that and to present the CSBARS, in particular Dean members' point of view. And Chair Frickberg, I don't know if you wanted to elaborate further.
Well, definitely. Also, if Shakar, if you'd scroll down just a little bit, that is the language that's appended at the bottom with the asterisk. So I think, and also Chair Kramer was part of these conversations and dialogues. So I think they're well aware of that. This was just an attempt by CSBARS to communicate as well as possible. That our first preference is no restriction, but if there must be a restriction, this is the language that we would be supportive of. And I would definitely echo that if I'm asked to comment on that.
Well, that's good to know. That, yeah, I'm comfortable with that representation.
And Dean
And-
Keller?
Yeah, just to follow on that, I thought what Dean Leal was asking was whether staff would be making its own recommendation on whether there would be a unit limit or not.
Oh, sure, I can speak to that. So in the memorandum that's posted, the staff recommendation is to include a maximum to assist the committee in instances where enforcement is necessary. But part of the context is that at that 15% limit for most schools, that should allow a school to replace all of their electives if they wanted to do so with bar prep. So it's really designed for the situation which we hope would never occur, in which the curriculum, the JD curriculum, is essentially replaced by a bar preparation course. It would give the committee an avenue to address that. But generally, it's thought that there should be a lot of flexibility, and that 15% should not apply to internships, which was a question that we got. And it also should not apply to general skills courses or practical skills courses like legal reasoning, legal research and writing, appellate advocacy, etc.
And Chair Kramer, I believe you were about to say something.
Oh, just to say that I would be supporting some kind of limitation. In fact, that was one of my big issues, when I came into this discussion.
Dean Leal, did that address your concerns?
No, I expected that. And I guess, Paul, just so we all know what will be said at the meeting on Friday, I mean, are you advocating for the 15% limitation or something different?
Just what's in the document here.
Oh, okay. Well, that's fine.
And similarly, it may be helpful for any members who want to clarify the point as to why a maximum might not be supported. If there are certain points that you would like Chair Frickberg to amplify, then that would be helpful.
And it also, just as a separate reminder for everyone, although we're on the CSBARS, we could also make public comment if we would like to the Committee of Bar Examiners. They have a very similar system of public comment if you'd like to have those information presented directly from you to them at that meeting. And you can always submit that in writing as well, which I know on our side, I always prefer for our committee. Gives us time to process things versus just hearing and responding immediately. So at this time, again, any further discussion, or should we entertain a motion to adopt 1.11 now as amended from this meeting?
Oh, this is Dean Park. I would move to adopt.
Do we have a second?
I'll second.
Ms. Garrett, could you take a roll call vote to now adopt 1.11 as amended, please?
Jay Frickberg,
Aye.
Michael Clancy,
Aye.
Linda Keller,
Aye.
George Lill,
Aye.
Paul Kramer,
Aye.
and Jessica Park.
Aye.
The ayes have it. So now, if I understand correctly, staff will now amend the attachment for the CBE meeting on Friday, sometime tomorrow. And that this now modified document will be the presented one from CSBARS. Definitely want to thank everyone. I think that we haven't had a more litigated rule or guideline, at least in the 3 years I've been on CSBARS. So if anyone asks, how well thought are these things through, I think as thought through as possible. As we can see, but it is a much better product. If you and again, encourage the public, especially roll back, when we started this process, compare this document to that. And I think it does show the benefit of that hive mind. And we all have different lenses and angles, and it is a much better document now. So again, thank you, everyone.
My thanks as well. Given, I suppose the argument goes that we've had 13 years to get this done, and we used every minute of that.
Well, I think last time we actually used more minutes than we had. But again, thank you to everyone on that issue. Our next and last agenda item is a discussion on research related to best practices for preservation of student records. Mr. Leonard, I don't know if you want to present. I believe there was something concerning BPPE on that matter.
Yes, I'm happy to share a little bit of background. And I will share my screen. Okay, so just to refresh everyone, I know this has been on the mind of CSBARS for a little while, but has been somewhat sidelined by the 1.11 discussion. So thank you everyone for refreshing prior to the meeting. The Committee of Bar Examiners asked CSBARS to consider the issues that might be involved in order to maintain that, determine that when a law school closes, that there would be a records retention process in place to make it possible for students or graduates from that school to be able to receive those records if they would need them. And why does this matter? In most cases, students are graduating in due course with all speed and taking the bar exam with all speed. And even if the school closes, they will have their transcripts on file with the state bar, and they remain on file as far as certification for the bar exam. In certain cases, students may not be finished with their course, or they may choose not to take the bar exam at that time and wish to take it later. And as part of gaining access to a bar exam, whether here or elsewhere, they do need an official copy of that transcript. And if the law school has closed, they still need a way to access that. And so at this point, what we're basically doing is determining how other schools, other accreditors, other systems take care of this issue. And there are some unique elements with accredited and registered schools. Most often for an ABA-related school, the record-keeping function falls to the university. So the school may not continue, the university may not continue a law school, but it continues as a going concern as a university, and that same registrar maintains the records. Here, we looked at a number of possibilities because the accredited and registered schools are different, sometimes standing alone, also being of a different size and scale. So we looked at how other groups are handling this, such as the Bureau of Private Post-Secondary Education, regional and institutional accreditors, escrow options, such as with the LSAC or LSDAS. And I also believe that Dean Frickberg will have another possibility as well. We know there are unique challenges when a school is a standalone school, especially when the school is a small school. Sometimes we've had owners who are individual owners who very carefully take care of records along the way, but they may pass. And we did recently have an owner who passed, and he did have essentially an estate plan for the records so that his graduates could continue. And that was a very generous and effective best practice. We also wonder the extent to having registration assist in this process, and whether it is feasible for the law schools to share copies of ongoing student records with the State Bar. What would be involved? What would be the cost? What would be the concerns? Is that practical? And what other options might come up? And I wonder, Dean Park, would you like to speak to the BEPI related system? Or if not, I'd be happy to go through it.
Oh, no, I'm happy to do so. Actually, this was from our subcommittee work with Dean Clancy. So as I go through this, Dean Clancy, also feel free to chime in. A lot of our subcommittee work was just looking at BEPI for one section. And we went first actually from a 7 steps to successful school closure guidance document that they had published on their website. And that led us to specific codes. So the first code, California Education Code 94926, specifies the need for a closing institution to provide a closure plan, which shall include as one of the following: a plan for disposition of records. And in 94927.5a, there's follow-up to that statement about the plan for disposition of records. So prior to closing, an institution shall provide the Bureau with the following: copies of pertinent student records, including transcripts in hard copy or electronic form, as determined by the Bureau pursuant to regulations adopted by the Bureau. So if audience members are aware, there was a time where the Bureau for Private Post-Secondary Education would approve institutions that didn't have accreditation. And so that's what one would relate to, but they always had a provision for if an institution was accredited. So that's number 2. If the institution is an accredited institution, a plan for the retention of records and transcripts approved by the institution's accrediting agency that provides information as to how a student may obtain a transcript or any other information about the student's coursework and degrees completed. And what's interesting about that, just as a benchmark, is that for an accredited institution, I see this as matching up more with what that accredited institution may need to provide its accrediting agency during self-studies or site visits. It's not necessarily, you know, a download of the pertinent student records right then. So I know there's more. So Natalie, let me know if you would like to have me cover more coming up. Okay. So 94927.5B, this touches on A. So subdivision A applies to all private post-secondary institutions, including institutions that are otherwise exempt from this chapter pursuant to Article 4, commencing with section 94874. And so when you pop over to that provision, it mentions law school in subsection G. A law school that is accredited by the Council of the Section of Legal Education and Admissions to the Bar of the American Bar Association, or a law school or law study program that is subject to the approval, regulation, oversight of the Committee of Bar Examiners and pursuant to those business and professions codes that we would know about well. So what's happening here, and I know it sort of jumps from one slide to another. What's important to read is BEPI is saying what they are discussing related to school disclosure, school closure. It applies to all private post-secondary institutions, including institutions that are otherwise exempt. And then 98874 mentions our law schools, California law schools within an exemption. But still, the point of 94927.5B is that this is one of the BEPI, this is one of the California Education Code that still applies regardless of exemption. When Dean Clancy and I looked at other codes that we could look at, we saw this other source mentioned a lot as we were going through the California Education Codes. That was also mentioning plan for disposition of student records. While the California Education Code lays out what needs to be met, 5 CCR 76240, you can see that as more agency guidance that fills in how to meet the California Education Codes. And I think this will continue most likely. So thank you. So again, going from these regulations that support the California Education Codes, 5 CCR 71930B sets a maximum time period for how long student records and transcripts need to be retained by an institution. It states in part 1, in addition to permanently retaining a transcript as required by section 94900B of the code, the institution shall maintain for a period of 5 years the pertinent student records described in section 71920 from the student's date of completion or withdrawal. Notwithstanding B1, the institution shall maintain records relating to federal financial aid programs as provided by federal law. And I think with that, that actually covers what Dean Clancy and I saw from those state laws that touched on this subject.
Thanks, Dean Park. Based on your research along with Dean Clancy, were there any elements of that that you thought might be particularly pertinent or useful for the accredited and registered schools as an initial thought?
Yeah, so Dean Clancy and I, in our response, we had a BEPI section. We took a look at other accreditor sections as well. But I think it was a good process for us to go through it and see the guidance from the Bureau. I thought it definitely offers a starting place. I think a matter of concern for logistics for us was, well, you know, it's very hard before you close for any law school to kind of think, oh, what are the processes for that? How is that done on a timely basis? To whom do I need to transfer these things? So I think being aware that this is what the Bureau offers in its guidance, that these are at least some of the codes that they're citing to when they go over their 7 steps to successful school closure. That seemed to be important for this group to be aware of, to look at this topic. And Dean Clancy definitely had some takeaways as well, some points of emphasis, because as we all know, for law schools to comply with different entities, there can be a different overlap of burden to that if requirements are different or processes are different. So I do want to let him speak to that. I do want to make this quick point though. We were thinking about, as we're going through our research, you know, when a law school is transferring all these student records and transcripts, whether to the state bar or to another agency, that has to be done securely. And also the agency that's hosting all of that later needs to have processes, systems in place, capacity to do so. And so I think looking at BEPI, this is my last point, looking at BEPI further and just seeing how they do so, they definitely have a website set up where members of the public can go and can request records from all of these different closed schools. It seems like they have a department or an office to assist members of the public with that. So there's a lot of capacity and bandwidth already there. And so it's a real question for us exploring this, you know, can that be built up somewhere else in the Bureau, or is it something perhaps to leverage within our discussion, knowing that the Bureau is already doing that? So those were some takeaways from me. Dean Clancy, happy to let you speak on your takeaways, because I know you had some different ones, but still very, very important ones.
Yes, well, thanks for that overview. Yeah, I do have a couple of comments. So first, I want to say that it was a surprise to me that the BPPE is mandated by law to accept these records, is obligated by law to take these records from closing schools. And I say that because I don't have any knowledge of a closing a law school ever having provided records to the BPPE. And I'd like to state also anecdotally that I've had the experience on a couple of occasions to help people who've needed transcripts from schools that have closed. And I've contacted the BPPE, and I have found each time that they don't have the transcripts. And they've referred me to numbers on a website. I've had to call the number only to find out that there's no one with the records, at least in the first instance. I've then gone back to BPPE to say on each of those occasions that I had trouble, couldn't get in contact with anyone regarding the transcripts. And eventually there was some help, but it wasn't the type of help that the law seems to imply should be available. You would think that the BPPE would be going to its own records to find these transcripts that had been submitted by the closing schools, and they don't seem to do that. And I'd like to now read from wording that we found on a web page for the BPPE, and I hope I can pull it up quickly here. I thought I had it. Well, I'm just going to have to paraphrase because I can't locate it now. But the wording indicated that the BPPE may have transcripts for closing schools, but that it won't always, that in some cases it doesn't. So I would like to know the particulars in that regard. Why does it not have the transcripts from closing schools? Is it only because the owners and the administrators are not complying with the requirement of the law, or is the BPPE not accepting the records? Seems to me we need to find out. But if the law is as what it seems to be, that's a great feature. That's a wonderful service that the BPPE will take transcripts from closing law schools. Also anecdotally, I can state that I've had students or potential students contact my school over the years saying that a law school that they had attended closed and the records, the transcripts were not available. And it was so frustrating to not be able to help those people. It would be nice if we could come up with something in the way of a storage way, or a storage unit to help. Would be great if it was the bar. But as Dean Parks stated, there may be liability issues connected with taking on these records. And maybe that's why the BPPE doesn't do it as often as the law would imply it should. Those are my only comments now.
I did want to mention very quickly, we did include a link, but I think it's only working doc that not the PDF, where the holds out a transcripts page, a transcript request form page. And they do go over records in the Bureau's possession, and they offer directory of schools that they have records for. So if that's of interest to the group, I know that it was in our editable file, but I have the hyperlink pulled up as well. And I think, Dean Clancy, this might be what you're mentioning, that there's a transcript page where you can request, and then the specific office that BEPI has is the Office of Student Assistance and Relief. That's running that page.
Yes, I found the wording that I was looking for, and it's on a page of the BPPE website under a heading Transcripts and Student Records. Here's the quote. In the event of a school closure, the school is obligated to provide a custodian of records, someone a student may contact to obtain a copy of their transcript. In some cases, a closed school will provide copies of transcripts to the Bureau, unquote. So that seems to be in conflict with what it looked like the law states, which is that the closing schools are obligated to provide transcripts to the BPPE. So that should be an area of inquiry for us. When I say for us, I guess what I really mean is for the bar. If the bar is interested in coming up with a way to remedy the problem that happens every now and then when schools close regarding transcripts, that may be a good place to start, to call the BPPE and find out if they interpret the law as making it such that the BPPE is obligated to take those transcripts, and if they don't think so, if that's not their interpretation, why?
I do want to mention that as an agency, and this is something ALU experienced since 1996, there are times when iterations of it have sunsetted. So for example, when it was BPPBE, it sunsetted for some time. So just as a possible reason for in some cases, it might be literally due to whether the agency was running at the time. So. With that, I don't want to take too much spotlighting. This really focused on our BEPI section of what our subcommittee went through. We did take a look at other sources as well, but that being said, I'm sure this is enough information to discuss. It's very relevant, on point, important for us to pay attention to in California. So if there is a chance to go into others, let me know, but otherwise happy to stay here if that's what's best for discussion.
And Dean Fickberg, did you also have a suggestion or thought for further research?
Yes, if I could. I think one of the issues that I've noticed in research, and I think also came in the presentation we just heard from BPPE, is it's in reference to a closing institution and versus a running institution. And I think, like most businesses, when they first start, no one thinks they're going to go out of business. I think every school that starts, no one's thinking I'm going to be a closing institution. And by the time they've switched to becoming a closing institution, it's probably too late to gather all those records. This has to be more of a foundational accreditation registration issue. My thought for further exploration would be potentially having the California Bar have a third-party designee. One example, and I have no financial interest in the spirit of our 1.11 discussion, but I think a great illustration of this is the National Student Clearinghouse. The National Student Clearinghouse, if you haven't looked or reference to that, I would encourage everyone to do that, every institution. They provide a great service, no charge to the institution, where they can connect live to your student information system, to your SIS. And I think everyone pretty much has an SIS. I don't know if there's still anyone in a paper format. Now they're all different, of course, Popoli, Zanzibar, we have Campus Cafe, some are proprietary, but they're core, they're just in the fancy spreadsheets. So they can populate. The National Student Clearinghouse already has thousands of institutions that it performs this service for, limited to just the transcript. And that would be my recommendation. Maybe we just limit this to not all student records, an official transcript, because that official transcript, I think, is what's most important to our opportunity mission students in California. That way they can take this is what I've earned, this is what I've learned, take it to their next institution. Instead of attendance, record keeping, the transcript itself to me is the paramount one. They can do that, again, institutionally already. So maybe they can do that for the institution of the state bar. And that way, every semester or every term, they just do a data pull, or someone sends this communication, which is encrypted, FERPA compliant, approved under the Department of Education for federal financial aid purposes. All of those hurdles have already been gone through in great detail. We've explored it separately, from the investigation of this process. We're looking at it because it'll make it easier for our students just to get transcripts. They, instead of contacting UWA, my institution, to get a transcript, they can contact National Student Clearinghouse and get a transcript much faster and efficiently at a lower cost. Because as we discussed before, I don't think any institution is really making money from transcripts. It's more of one of those things that we need to do, but they can do better. So that'd be my recommendation. Limit the record keeping to official transcripts. I think that gives the best benefit to the student. And then have a third-party designee like the National Student Clearinghouse or someone like that, where schools can export their data. And then that's a live rolling database, because no one's planning on going out of business. I don't think anyone ever has that thought. And by the time it does happen, too late, it's no longer an issue. So I hope that might be helpful, at least in exploring.
Thanks, Dean Frickberg.
So is there any further discussion on our last agenda item from our committee or staff?
Sounds like if there is no further discussion, a reasonable next step would be for staff to look into both the transcript form request at BIPI and then also the Student Clearinghouse to determine how they work, what they cost, but also when records are missing, what are the most common reasons, and see if it's similar to the experience of state bar accredited schools or state bar registered schools. Informally, no motion needed. Does that sound like a reasonable next step of preparation of information that would be helpful for CSBARS?
It does to me, and I see a lot of heads nodding yes.
Yes.
Yes. Dean Leal?
Yeah, and if I read or heard what Dean Park was saying, it sounds like maybe another guidelines needed in terms of record keeping that. And I wasn't sure on the timing if schools under the statute we were looking at should have a plan already in place, or is it when they've made a decision to teach out and close, that's when a plan would then need to be created and implemented. But some guideline probably would be helpful to provide the advance notice to all the schools as to if and when you decide to teach out and close, here's what you need to do.
Another general thought starting question is what incentive might be appropriate for a school, especially a small school, to have a plan when they close. So for example, the filing of a bond or another requirement that would encourage the creation of a robust closing plan. We haven't briefed that specifically, but perhaps incentives in that regard might be helpful. And we can look into that to bring this back to a future CSBARS meeting.
I like that idea. I like Dean Frickberg's suggestion a lot. I think it's great. But if we can't go with that suggestion, I think there should be discussion about the trigger for what should obligate a school to do something in the way to guarantee that transcripts are somewhere after it closes. The trigger event could be just, for instance, non-compliance, a notice of non-compliance, or it could be some other event that involves suggestions by the owner of a school that the school's in trouble. But I think there should be discussion about a trigger, and it could be put in the rules, it seems to me. All of it's important, that's for sure.
Well, thank you everyone for taking another step in this discussion, and we look forward to bringing additional information back to the group to ultimately create a recommendation for the committee.
And I want to thank you all for the work you've put in so far. It's really helpful.
Any further discussion on our last agendized item? Not hearing any. Ms. Leonard, are there any other additional items that were not on our agenda?
No, there are not.
It's excellent. So in contravention of our last meeting, instead of going long, we can end early. But Dean Clancy, I won't let that stop you.
May I jump back to a prior agenda item? This is the one that involved the annual report. Will there be an extension of the deadline for submission of the report due to the fact that we're getting the template for it later than usual?
That's not contemplated overall. The hope is that because the data that's being requested is similar to what's been requested in the past, and we'll be providing additional support prior to, we think that most schools should be able to collect the data in the typical amount of time. So the November 15th data deadline is what's continued to be planned.
All right, so there are no significant changes then comparing this new template to the old one, such that there would be additional work required?
We don't believe so, and we will be talking with each school individually, including your school, in case the school should think differently or should require additional support. And we do want to be there for the schools to help you create what you need the way that you need it. And for those schools that may have new staff or that may not be fully aware of all the elements related to the transition, then we'll be there to help. So look forward to calls from us in the next couple of days, setting up those appointments for the next week or two, and look forward to a good conversation.
Thank you.
So unless there's any objection, then we will close our October meeting of CSBARS, and I'll make sure our record reflects again 22 minutes early. So I'm giving back that time to you that I stole last time, but I thank you for allowing me to steal it. And thank you and goodbye.
Thank you, everyone.
Thank
Great.
you.
Here.